Welcome, everybody. Thank you for joining us for the second of the CC webinars with our legal folks. And Shayna's going to trim this, so I will get the intro much better second time around. There is, what was I going to say? This is being recorded, so if you don't want to be on the recording, you're welcome to keep your cameras off. Otherwise, if you want to have them on, that's lovely, but there's no requirement to have your cameras on. This webinar is our licensing Q&A with Kat Walsh. And Kat is, if I just had it, there we go, is the Copyright and Licensing Counsel at Creative Commons. She was on the CC legal team in 2012 to 2015 during the drafting and initial publication process for version 4 of the license suite, and returned as Deputy General Counsel in 2021 and General Counsel in 2022 before moving to her current role. She has nearly 20 years history in the free and open culture movement, including many years on the boards of Wikimedia Foundation and the Free Software Foundation, and has previously worked in library policy, technology startups, and online community management. Kat is an advocate for free access to knowledge and for CC licensing as part of the infrastructure for an internet that belongs to everyone. Such a nice statement. Okay. When not practicing law, Kat is also a bassoonist, violinist, choral singer, and power lifter. Love it. She is based in San Rafael, California. And with that, I'm going to turn it over to Kat.
Hello. Lovely to be here. I hope that you can hear me on the screen. I think that you can. I will start with some of the questions in the document, and I'll first start with the disclaimer. I am a lawyer. I am not your lawyer. So what I'm going to do in this session is try and answer the questions as best as I can and talk about the legal principles involved in a lot of the information that you need to know. What I can't do is give you specific advice for what you should do in a particular situation, but I will try and be as helpful as I can around that. Without further ado, I know there are questions in the doc, but I know that maybe not everybody who asked them is in the room. So if somebody is in the room and you would like to ask your question, you can please either ask it in the chat or speak up on the or just point out which question is yours, and I'll start with those first, and then I'll get to the rest of the ones on the document. And if nobody wants to jump in, I'll just start with the ones that I think I'll start where Meredith left off, and I think she started with the first 10 questions.
So we're going to start with 11?
Mm-hmm.
Okay. So question 11 is, would a Wikimedia volunteer researching for a Wikipedia article be viewed as conducting non-commercial research? I know that uploading a work to Wikipedia would be considered commercial and so would need to be licensed appropriately if it was copyright. I work in a UK library, and if a user requested a portion of a published work under library privilege exception for non-commercial research / private study, I don't know that, some part of the UK Copyright Act, could this be given to a volunteer researcher to inform their writing for a Wikipedia article?
So I will continue my disclaimer and say that I am a United States licensed lawyer. I'm not licensed in any other jurisdictions. I know some about other areas of law, but I am only licensed in the United States. That said, so I'm not as familiar with the UK Copyright Act as a UK licensed lawyer would be. But in general, in that case, if you're not making a reproduction of that work and you're doing this for a non-commercial project, especially if you're not reproducing the material, you want to write an article about redwood trees, which I'm thinking of because there are some lovely ones right behind me, and you request an article about red, and you're not making copies of that, you're doing that research and you're just going to use it as background. Usually that would be fine. But I think it's very fact specific. I think in the case of Wikipedia, because that project itself is a non-commercial project, even though it is licensed permitting commercial use. And you are not actually reproducing the material, you're just using it as background study for the original material that you're going to write. that should generally be fine. But that's one of those things where I think it's, number one, going to be very fact specific, and number two, if this is very important to you in the UK, that you should probably consult local counsel and make sure that that's going to be okay in your jurisdiction.
So, I should probably also mention, if y'all want to ask follow-up questions, you're welcome to do that in the chat, and I will read them out loud. I've also put a link in the chat to the questions document if you want to follow along there. Okay, we on to the next one?
Yeah.
Okay. How does the non-commercial condition in Creative Commons licenses apply when commercial entities share or repost the CC licensed content? For instance, if a company posts a CC image on their website or social media to attract attention or engagement that supports their business, does that count as commercial use?
Yeah, so commercial use usually hinges on like the use and not the user. Like, is it a commercial use? Like, it is possible for a commercial user to make a non-commercial use. But in general, the presumption is that if you're a commercial user and you're publishing it on your social media, like the presumption is probably going to be that you're doing that in order to like attract people to your business because you want, more people to engage with your business for some commercial purpose. The language in the license is not very prescriptive on this. It's like for primarily intended for like financial or economic advantage, things like that. And there's not a whole lot of case law around it. But in those cases, I would probably, if I were a commercial user, if I were a company trying to repost material and to try and get engagement, I would probably bias toward using materials that were either licensed for commercial use or getting specific permission if you were trying to use non-commercial licensed material. Because the presumption is probably going to be that you're doing this for some commercial advantage. You're not just doing this out of the goodness of your hearts. You like to share material. It is possible that if you're a commercial entity and you're running like a charitable campaign, like you've got either like a foundation associated with you, or you're doing it for a purely charitable purpose, that you could use a non-commercial licensed material and it would be fine and it would be found to be non-commercial. But in general, if you're doing it to support your business activities, that would probably be seen to be a commercial use. And there are not black and white rules on like what exactly this is commercial, this is not. But like the presumption is probably going to be that if you're a company doing it for that, it's going to be considered commercial, and you should get permission. And I see a hand up.
Yes, hi. Katja, I think you mentioned the term case law, right? Would you like to explain that to the participants? Because I think this is not clearly explained in the course content.
Oh yeah, so because the license is not very prescriptive about what exactly counts as commercial use or not, there have been a couple of times where Creative Commons licenses have been taken to court, mostly in the United States. I think there have been a handful in places like Germany, where people have had arguments over whether a particular use was a commercial use or not. We do have a legal database, and Suzanne, maybe if you could drop that link in the chat. We do have a legal database with all the cases that we know about where courts in various jurisdictions have like looked at issues where people have actually brought it to court, and you can see how those came out if you look at the cases in our legal database. And that can give you some idea of what a court might consider commercial or non-commercial, because in any specific case, they might weigh certain factors in determining whether that is true or not. But yeah, the case law is just like what courts have actually decided when trying to interpret what the license means in light of like people's specific facts and how they've been using the material.
So some court decisions can affect follow-up court cases, right?
That's right. Right, and particularly court cases will usually affect you if you're in the same jurisdiction where the court was. So if you were in like a United States, district court, everybody in that district, that's probably going to be like controlling law. Or if something went as far as the Supreme Court, it would probably anywhere in the United States, you'd know that that was the situation. If something was only at a local court, that might not apply to you, but that might not necessarily apply to you, but other courts might look to that as an example when they're deciding their own cases. So if you've got something that happens in another country, that may not apply directly to you, but a court in your country might look at that when deciding how to apply their own law. So only things in your specific jurisdiction in like in a court, like a Supreme Court or a district court or something that's controlling would be like, yes, absolutely, they're going to do it this way. But courts will always like look at each other to determine if they haven't had a case like that before, and they might take it as informative, even if they're not required to decide the same way.
I have a follow-up question, if that's okay. So just speaking of kind of case law, and one of the things that comes up a lot, I'm in the US at a community college, and the NC license our bookstores are always kind of iffy about, right? And my understanding is that because of, I don't know, some case, and I don't remember what it was, but it's okay for a bookstore to sell content that has non-commercial element as long as they're only selling it for like overhead. So my question is, one, is that true? And two, does that mean that that's not true all over the US because it's in a small space, and then also more broadly globally?
Yeah, so it's generally like been the case that and I think it's one of the cases it's called like a copy shop case, and it was like FedEx Kinko's like or something where somebody brought non-commercial materials to like a commercial copy shop to be like, you know, and the copy shop like wasn't, you know, they didn't care what the material was, like you pay them for copies, you get a copy, like that's a, and they don't care if it's non-commercial license, they don't care if it's Creative Commons licensed, but it's just like you bring them 500 sheets of paper, you pay them for 500 sheets of paper, like that's what their charge is. And it's not like they're charging for access to that content. And similar with a bookstore, like, you know, they have, you know, if they're not making a profit on the content, it's just like you need 500 sheets of paper, they give you 500 sheets of paper, they charge you for like those sheets of paper and maybe a storage cost, like that's generally seen to be okay, as opposed to like they're going to charge you like a premium for the particular content that you use. I think it's generally fine for the bookstores to do that, like whether a bookstore can charge like additional profit for like overhead, you know, like staff pay, you know, things like that is a little more questionable. Most people I think have like acted, pardon me, most people have generally acted in the assumption that it is okay. I think most of the non-commercial authors like are fine with this, like the bookstore like covering their expenses and covering their expenses and selling the material to you, but not like making additional profit on selling that material to you. It is pretty fact specific. And again, if you in a case where you're uncertain, it's always best to go back to the author or rights holder and saying like, hey, I have your non-commercial material, I want to use it in this way. Like, are you okay with that? I think most people who are writing textbooks that are non-commercial expect them to be sold in like college bookstores for the copying costs, things like that. That's, you know, that's kind of what they intended it to do. Somebody with other non-commercial material, maybe not as clear. But it doesn't completely forbid the exchange of money. It's more like, are you profiting from like giving somebody access to this material in particular is usually how it's been interpreted.
So thank you. Appreciate that. Okay, on to question 13. Are there examples that trace the chain of derivatives created under the SA license across multiple users?
Oh man, it's, you know, it's hard to like think of good examples of that, and like maybe the most prominent example is not one that's a great example for everyone in that Wikipedia is all like share alike, and both the articles, the text articles, and a lot of the pictures that are in Wikimedia Commons. A lot of those are under share alike licenses, and the way that they trace the chain of derivatives is on their history page, where you can look and step through and see what edits everybody made. But that's not a system that's going to work for everybody. We do have some examples on our marking page of how to mark adaptations. And I think, Suzanne, if you could put that in the chat, I think you're already on it. We do have some examples of how to do that, but I don't actually like know offhand of a good example where people have traced the chain of derivatives. It's like, yeah, I would have to think of that. We do. Yeah, it is true that if you are making an adaptation of an adaptation of an adaptation, you do have to acknowledge all of those authors, and various people will do it in various ways. Like there's not a set form for it. You just have to include all the information in a way that's appropriate to whatever context you're doing it. So, you know, a book, you might acknowledge somebody at the end of the chapter, or you might include it all in the front matter or the back, you know, or the back of or at the end, but there's not a set way to do it. It's just you have to include all of that information in a way that's reasonable for a user to find. But we do have some recommended practices for attribution that gives, I think, at least one or two examples of how you might do it across adaptations. You can also look to a lot of software licenses that are similar to the CC licenses. Like particularly the GPL is the best known kind of copyleft in the same spirit as share alike, where they also have to trace different authors across adaptations, and a lot of those will have a separate file where they acknowledge the authors and like what the changes they make. And that's also a totally fine way to do it, to have a file where you acknowledge all the authors, especially for something that's really massively collaborative.
Does anyone have follow-up questions on this? I am not seeing anything in the chat, so if y'all want to ask questions, please feel free to do so. But if not, we'll move on to 14. Is there a straightforward way to explain the main possibilities and restrictions under SA? For instance, if a filmmaker wants to use the cover of a book released under an SA license in an all rights reserved documentary, they would need permission, correct? But could that same filmmaker share a copy of the book in marketing materials for the film without additional permission?
So that one's an interesting case. So normally I would think, like, if you're making a film and you're just using the cover of a book, for example, if you're making a documentary about that author or something like that, often you might not even need copyright permission at all, and you might check to see if an exception or limitation to copyright, such as fair use or fair dealing, would apply to that. Especially if you're just like, you're using the cover of the book because you're talking about the work, you're criticizing that work, you're talking about it in context of that author's life, things like that, and you just like need to show the cover. You might not need copyright permission, and then the CC license wouldn't apply even if it were a share alike or a non-commercial or something like that. If you are using it in a way that would require copyright, oh, and I will say that film, like that publishing companies and like, you know, maybe your insurance company, if you're making a film, like may often require you to get copyright permission for their purposes, even if like under copyright law, you wouldn't need it. So maybe you need like a permission statement, even if you would be permitted to use it under fair use or fair dealing. We see that a lot with things like documentaries or things like critical material, where you're going to be using a lot of an author's material. And that's kind of awful because it does restrict people from making those critical works, but like your publisher or your insurance company or whoever you're dealing with may want that anyway. But if you are using it in a context where you are making an adaptation of that cover, like that's where the share alike license would come into play. You're taking the cover of that book, for example, and you're using it as inspiration for your own artwork, or you're remixing it and making your own cover that, you know, that is very similar to it, then you would need either specific permission, or you'd need to follow the conditions of the share alike license. But often you wouldn't need copyright permission. So if you were making an adaptation, and that's like you're taking the artistic work and you're adding your own artistic work to it in some way, so that you've made a new artistic work that incorporates that one, then yes, you do need permission, or you need to follow the conditions of the share alike license. If you're just using it in a critical context that's allowed in your jurisdiction, like you're using it to talk about the work, then you probably don't. So if you're sharing a copy of the book and marketing materials for the film, like I'm not exactly clear on what that means, but say you're just like, you're referring to the book, or like you sell that book at your table when you're talking about the film, then you would not need specific permission because you're not making an adaptation, you're not making a copy, you are just distributing the book as is under the terms that it's permitted. You're not, share alike mainly comes into play when you are making an adaptation.
Can I ask a quick follow-up question to that? And I think you may have touched on it, but I just want to make sure I understood. So let's say that same book, I make an adaptation of the cover because I love the cover, but I'm writing my entirely separate book inside. I just really wanted to use her cover. Since they're linked, do I have to use SA for the rest of my book?
You do not have to use essay for the rest of your book, usually. Like if your adaptation is only of like the cover art, for like you could say that those are two separate works. Like your book is not an adaptation of that cover, just like only your cover is. So you're distributing two works. You're distributing the cover art and the text of the book, and they're not really related to each other. So I would say the rest of your book would not have to be essay. And like I'm sure anybody can think of cases where like they're so closely linked that of course the book is an adaptation of the cover, but in most cases the text of the book is not going to be an adaptation of the cover art.
Perfect. Thank you.
Oh yeah, I will add one thing to that, which is if you're making an adaptation of in that case where you're making an adaptation of somebody else's cover for your own, note that the license only covers copyright. Like if you could be considered to be infringing on the personality rights, say if the cover included somebody's picture, or like trademark rights, if they were like, if they had one of their trademarks on the cover, like, a title or like a character or something like that, where like it wasn't just copyright in play, you might need to look at that too.
All right. Okay. Cool. So the next question is about the other element that causes lots of confusion, which is NC. It seems simple. Don't use my works to make money, but the boundaries aren't always clear. When is nonprofit considered commercial? What about a YouTube channel that runs ads or a teacher distributing materials in a paid workshop? Real world situations rarely fit neatly on either side.
Yeah, I think whoever asked that has a very good understanding of like non-commercial and like how difficult it is to determine sometimes, because these are not things that we have these are not things that we have black and white answers where we can just tell you, oh yes, this is definitely commercial or this is definitely not commercial. It is kind of fact specific. We did do a survey at one point where people gave their opinions on, and this survey is about 15 years old at this point, where people gave their opinions on whether or not something was commercial. Oftentimes what we've seen in practice, but we have not seen specific cases come up in court, is this like, if you're simply posting the material on YouTube and like YouTube runs ads, because like basically every site where you can post things for free runs ads like alongside, like people are generally okay with that. If you specifically are including an ad with your content, like, you include some non-commercial material and then you talk for 30 seconds about Blue Apron, which is one that appears on like all the podcasts, like maybe that's a little different. Maybe that feels like you're monetizing that, you specifically are monetizing that content and not just like, oh, I wanted to post this on YouTube, so I had to allow them to run an ad beside it. In the case where you're not sure, particularly if you yourself have like entered into a deal where you were making money from distributing that content, I would probably bias toward either using material that's licensed commercially or asking specific permission from the licensor, because I think that's more likely to be considered commercial than something where you're simply posting it on a platform and that platform runs ads besides everything, not caring about what it is. A paid workshop, also a little difficult. Most licensors are okay with like, including non-commercial material incidentally in like educational courses where like you're paying for like the teacher's time basically, and they're just using a variety of materials versus like you are paying them specifically to teach about like the thing that you have put out. My general advice for situations, a lot of situations in Creative Commons, is do something that you would not be embarrassed to explain either to the author or to a judge about like why you think that your use is in adherence with the spirit of the license. Most of the time, like if something feels correct to you, it is probably going to be fine to the licensor. If you're not good at judging that, ask your most trusted friend. But it's true that there's not a lot of good guidance on specifically like this situation is okay, this situation is not. We do have the legal database where you can look at how cases that actually went to court came out. But a lot of times the like, does this feel like it's within the spirit of what the person intended by saying this is non-commercial? And that's very hard to judge. And it depends on like what your level of risk tolerance is also. Like what happens if you get this wrong and the author comes after you and says like, no, this is commercial, like, and Is it something where you'd be liable for a large payout, or is it something where you just say, oops, sorry, I'll stop doing that and take it down off a website? Like these situations can be very different, and like how much you or your institution have the ability to handle that when it goes wrong may determine like what side you come out on determining to use material where it's not clear.
So that raises an interesting question. Because one of the things, and again, stop me if I'm misunderstanding, is with the 4.0 licenses, if you do it
Mhm.
wrong, the author would tell you and you have a certain time to fix it. But if it's the NC, so I'm making money and the author disagrees that this was appropriate use, right? I have a certain amount of time to fix it and I do that. What happens to the money I made prior to that?
Yeah. So in that period, like you may still be liable for some of the profits that you made, like but it wouldn't be like an indefinite thing, like they like, oh, I was sitting on this for 2 years watching you make money, so now I want all your profits, versus like, oh, I found this in like for 5 days, and then you fixed it. Like those can be two very different situations. Uh, and then
Thank
it
you.
wouldn't.
Okay, so the next one is more about NC because this causes a lot of
Everybody.
confusion. So in this particular one, we have someone that wrote a biography that's CC by NC, and a nonprofit organization wants to share it. So they share it out on their website and talk about how supportive they are of open access and all of these sorts of things. Then at the bottom of the page, it says, if you want to support our work, please consider making a donation. And that's maybe at the bottom of every one of their web pages. So how would that fit in?
And again, this is one of the situations that's not like, we don't have a definite yes or no answer. And I see that Rebecca put the defining non-commercial report where there's some more survey information in there. In general, most people consider that to be okay. Like even though there is some it's not charging for access to the work. It's kind of like, if you like this, you can support the work of this charity. There may be cases where authors object to that. Like I haven't seen that many of them. I can't think of a specific example where somebody's like said, no, you're violating my license because you're doing this. But there's not a definite answer. Like I don't know what would happen if you took that to court. But I think most licensors think that that's okay. Like please don't donate to our charity if you liked things like this, versus like a commercial organization posting it and asking for like money for their products and services. So,
There's a second part to that, which I'm going to actually, I think, slightly change to make it even more complicated because I like to do that. Is what if the nonprofit changed the formatting so it printed better? So the original version just prints terribly, and they changed the formatting to print it better. And then they had, if you want to download this, consider donating to us, and it's still worded, consider donating.
Yeah, like this is one where I just can't give you a definitive answer. Like kind of try and figure out like what case you would make if it were challenged, and like what would happen if you were challenged, and decide what to do based on that. But yeah, there just isn't a good definitive answer. Like, yes, this is definitely commercial. Yes, this definitely isn't. Try and make your best case for why it is or isn't before you post the material or consider getting specific permission. And I see in the chat there's a further that hybrid business models seem to become the norm, especially online. So it gradually becomes even more difficult to specify non-commercial versus commercial reuses, and donations seem to be context specific. I think that that's true. And I think that in that case, like, again, it does depend on your risk tolerance. And if you're not sure if a use is commercial, you should either use material that's available for commercial licensing, or ask the rights holder specifically, like, hey, I want to use it this way. Do I have your permission?
Just a quick follow-up on that. Sometimes it's really hard to find the rights holder. Like how much effort are people expected to put into that?
Yeah, I would say, like, make reasonable efforts. Like if you can find them, like if you can find them via a web search, if it takes you, say, less than an hour to find them, like you probably should have made an effort to find them. Like sometimes they really have disappeared, or you can't find them, or they don't have information even available where you could find them. And in that case, it is really just up to your risk tolerance. Like what happens if they, how likely is it that they will see your post and object to it? Both the like how visible is it and like how questionable is their use? Did you really need permission, or were you just going to ask to get more certainty? Things like that. If you can't find them, like do your best to adhere to the conditions of the license. But maybe that biases you toward like being a little more conservative with that material if you can't find them and ask them for permission.
Okay, thank you. Okay, next question. The Open Government License, OGL, is intended for public sector information. To what extent is it more suitable for this type of data than Creative Commons licenses, and what factors make it preferable?
Yeah. This is one where I actually like I would have to like reread it and remember like what it is that they specify. I believe that this is one where they add some conditions that apply, like even that they add some conditions that would apply in contract even where copyright doesn't apply. Let me like take a quick look, because I don't want to say things that aren't true about it. One thing I will say about the Creative Commons licenses is that they do extend only as far as copyright does in your jurisdiction, and they are internationally valid. The Open Government license, I think, is a little more specific, but this is one where I should actually like look and see what I'm talking about before I go in there. I do not remember what all licenses say. I remember what a lot of licenses say, but
can I ask something about this question, because I dropped it in the document and it has appeared in the participants' assignments last year and this year, and sometimes the Open Government license is found in cultural heritage data sets. And the question is, if you have a cultural heritage data set under an Open Government license, because public cultural heritage institutions, sometimes they, under the public sector information law, they need to publish public sector information under an open license. So does a cultural heritage dataset under an Open Government license is compatible with a cultural heritage dataset under a Creative Commons license? So this is my first question. And also, Open Government licenses are country specific, or is there an international license for open government public sector information? So 2 questions.
all right. So I'll say it is compatible with the Creative Commons licenses. When you're distributing data sets that are under the Open Government license and you want to distribute them alongside Creative Commons licensed work, you need to make sure that you're complying with both licenses. That's usually pretty easy because the requirements of the Open Government license are not very strict. You need to acknowledge the source in the license and not do anything that's prohibited. And similar with the Creative Commons license, you need to acknowledge the source in the license and not do anything that's prohibited. But that's usually pretty easy to do. Just like having the credit statements for both sets of works is usually enough, and like mention like, this data under blah, blah, blah under the Open Government license, this data blah, blah, blah under the Creative Commons CC BY license, and that's totally fine. So as I did doing my quick refresher on the Open Government license, it looks like it does apply to Crown copyright works, which are, works from the United Kingdom and various Commonwealth countries. I don't know if there is a version for for countries with other legal frameworks. I think the Open Government license is specific to those works. But it is, it should be easy to use those materials together. If you're making an adaptation of a data set that's under a Creative Commons share-alike license, like that may be a problem. There are not a whole lot of data sets under share-alike licenses because it's not a great license for data sets. Like, what does it even mean to make an adaptation of a database? And we don't usually recommend that people do that. We recommend that people use CC BY for things like that. That may be a problem, but if you're using with CC BY or anything without the share alike condition, that should usually be fine. And you just need to make sure to acknowledge the source and licensing information of those works.
So the next question is actually related, and it's asking about the CC licenses with software. Why does it not generally, like, why is it not recommended? And is there any work on making the CC licenses sets for software that also include the NC, ND, and SA elements?
Yeah. So the main reason we don't recommend CC licenses for software is that there are already a lot of software licenses that have been in use since long before Creative Commons was even founded that are the standard for the way that software is released. And a lot of them include very specific conditions that make it more, that make the rights of every user more meaningful. Like particularly a lot of them will specify like how and when the source code needs to be shared. And the CC licenses don't do that because they're intended to be very general to things like music and movies and books and things where it may not even be clear what like a source format is or if it should be shared and things like that. And software has a set of a set of customs and practices where like, oh, there is source code, like that's the way people share things to allow it to be reused. So if we're going to make it meaningful for people to be able to share and remix, we're going to say you have to share the source code. That's really the main thing. And if you want to be compatible with those software projects, like it'll just introduce confusion if you're introducing a different license, the CC license that has different rights and different conditions. We just recommend that you use a software license so that you're not creating licensing confusion with these other software projects. There's no legal reason why you can't use Creative Commons licenses on software. We just, for compatibility reasons and to avoid introducing new standards and more confusion, we recommend that you don't do it. You can always dual license. For example, if you want to release a contribution to a project that's under the GPL, but you want to also allow people to use it under the CC terms, you can dual license under a CC license in the GPL. That's fine, so that somebody can use it under either or both. And it's just it's not standard in the software world to use things like non-commercial and non-derivatives license just because of the way that software gets used. A lot of it, most of it gets used in a context that could be considered commercial in some capacity. It just like it's not part of the norms and practices of software to use the non-commercial licenses, and none of the widely used software licenses have that term. Ditto with non-derivatives. Like there are people who distribute software that you can't modify and remix. It's usually called like shareware, and often they won't even distribute the source because they don't want you to share and remix it. And that it just like you can't remix it because you don't have the source code. Like so they don't do that through licensing generally. Anything where they give you the source code is usually meant for you to be able to share and adapt. So basically, like there's already a good set of like standards and cultural practices in software, and that CC doesn't want to add complication to that. There's already organizations that are especially like the Free Software Foundation and the Open Source Initiative and things like that that are thinking about like how to make copyright support the software ecosystem, and CC just doesn't need to add complication to that mix.
And there's just one more question on the document. So if y'all in the room have questions you want to put in the chat, now's a good time to think about that. Otherwise, there's plenty of questions I can pull from previous webinars. But the last question is always a good one here is, can I include materials with all rights reserved in a CC licensed work under fair use doctrine? When does such a reuse qualify as fair use?
Yeah, so the answer is yes. And again, one of the best examples of this is Wikipedia, which were all the material contributed by original contributors to Wikipedia is under a CC license. The text is all share alike, and the media, like the pictures and things, are under a variety of open licenses. But Wikipedia intends to be an encyclopedia of everything, basically. So, and sometimes what it is talking about is material that's under copyright. It's talking about music and movies and books that were not released under open licenses. And they do include excerpts of those materials in order to talk about them. And those materials are being used under exceptions and limitations to copyright, generally fair use in the United States. Other jurisdictions have things like fair dealing or statutory exceptions, things like that. And you can distribute those alongside. And those are going to be very context specific. So in the context of like, I am producing an encyclopedia or I want to talk about works that are in copyright, like that's, that's under an exception in pretty much every jurisdiction in the world. Like you can use a little bit of a copyrighted material in order to talk about it and criticize it, and you teach others about it. But if you were just like, I'm looking for material to reuse, and you see an article where like there is a bunch of CC by SA licensed text, and it includes a photograph excerpt, like say a small excerpt of a painting or something, your use of that excerpt may not be a fair use in your context. So if you're reusing a material where it's including a mix of openly licensed material and material used under an exception, you always need to check in your context, is that still an exception or not? So the freely licensed material, you can always use it as long as you're following the license terms and conditions. Material used under an exception alongside it, you'll need to check that every time to make sure that that your context still applies for that exception or limitation to copyright.
That's good. Two follow-up questions to that. So you mentioned like talking about a work. So let's say I'm writing an art history textbook, and I was able to go see, one of the famous paintings, and I took a picture of it. Can I use that? And then related to that, what if it's a 3D work and I take a picture of it? Can I use that?
Yeah, so that's a thing where you'll need to check and make sure that the law in your jurisdiction like allows for that use. And I know in the United States law best. So that's where I'm going to talk about examples, and the United States uses a kind of like very kind of like loosey-goosey test on the factors that apply, like is it affecting the market for the work, and like how much of the work did you use, and like what's the intent of your use, things like that. Often that will be fine if you've taken a picture and you've taken a picture and you printed it just large enough that the reader can see what you're talking about, and you needed to have that visual reference in order to talk about things that are important. Probably fine, and it doesn't. It may not make much of a difference between like whether you're just reproducing a 2D work or a 3D work. It's more like, why are you using this work? Like, did you need to use this work in order to make your point and to support your criticism and commentary and free expression and things that the law like wants to allow you to do? Or are you just like, reproducing it for, here's a pretty picture for you to look at, like that you could have bought from the museum shop, but I'm going to put in my textbook. Like that's a different use from like, look at this use of color, like in, 1912 as opposed to 1920. And like, isn't that interesting? Things like that.
And does it matter if it was a picture of a 3D work? So a sculpture?
In general, it doesn't matter. That may make a difference as to like, how much of that work did you need to use, or what kind of like reproduction, like what kind of reproduction is okay. But in general, like if you're permitted to like make a copy of a copyrighted work, if you're doing it in a reasonable manner that like was not more than you needed to do to make your point, that should be, that should still qualify for your fair use exception. But it is fair use is such a fact-specific thing, and in countries where it's more strictly specified in law, you may have more guidance. A lot of the civil law jurisdictions, particularly in Europe, will have very specific, like, oh, you can do this, you can do that. And the downsides of that are like, if it's not written in the law that you can do this, you may be prohibited, even if it seems like a totally reasonable use. But if it is written in the law that you can do that, like you are allowed to do that. Like it's the law.
That actually ties into one of the other questions, which is what does and doesn't constitute an adaptation, especially in consideration of something like a photo with an ND license.
So usually an adaptation requires that you have reproduced the material and you have added your own creative material, like in a way that like your addition to it would itself be copyrightable to make a new work. Things that are not adaptations of, for example, an ND work is like, are you simply taking an excerpt? Like, you know, are you simply making a technical change to make it like fit into like a format? Like you've got a video that's like the wrong proportions for a screen and like you cut it off a little bit. Like that's generally like not an adaptation. You're taking a material and you see a couple typos in it and you want to correct those before you distribute those to your class. Like that's usually not an adaptation. Like that's not a copyrightable creative change. You're just making some small corrections. Something that would generally be considered an adaptation, and again, this is something that's very fact specific, is, oh, you have a book chapter that's ND and you want to distribute to your class, but you notice some things are like out of date or say things in a way that you wouldn't want to say them, and you edit that material. That would generally be considered to be an adaptation because you're making creative changes that are not necessarily what the author intended. Maybe that's even why they put the ND license on. But things like technical or format changes, or you just want to use an excerpt, like it's a change to the work, but not a creative adaptation. Things where you're adding your own material, your own creativity, your own opinions, that usually is considered an adaptation. But again, it's very fact specific. It's hard to like say like, oh, this definitely is, this definitely isn't.
What about if I'm doing something like a collage? Right. So I'm not actually changing the work. I'm not touching it. It's there, but it's part of a larger work that is now significantly different.
And that one, I would say it could be like, and super hard to like, super hard to make that determination. Like one of the cases where I actually don't know how it would come out is, those materials where you see like a giant picture and you like zoom in and you see that giant picture is actually, like 10,000 photos like all arranged together to make like one bigger. Is that an adaptation or not? Maybe. I think you can make a pretty strong argument either way. I don't actually know if one of those has ever gone to court. If you're like making a collage where like, does it look like separate works distributed together, or does it look like it was made into another work as a whole? Like that's one where it's kind of like where it's very fact specific, and that's one where you might have to either be conservative with what you use or determine like what your risk tolerance is if like the author doesn't like it.
And that actually ties in really nicely to an assignment that I think is upcoming in the course, that is always confusing for folks, is where do you draw the line between a remix and a collection? Like how do you think through that?
Oh yeah. Yeah. How many angels can dance on the head of a pin, kind of like it's so, a thing that we've liked to say recently is copyright law is based on vibes a lot. And like, does it feel like these are separate works, like just you're distributing them together, or does it feel like you have made a cohesive whole out of these works? And when does that happen? Like who can say? And big copyright law cases, especially in the United States, you'll often have like, testimony from like art professors and things like that, artists and things like that, as to like how creative was this and what did they do? And once you've gotten to the point where you need to bring in art professors to talk about whether something was like an adaptation or not, like it's not a clear-cut case. Like this is just like has gotten into philosophical crazy land about that nobody could have known ahead of time. So it's very hard to say. And it's kind of one where you need to like, if you're not sure, you may want to ask for permission or just take the risk that you're wrong. And there's not a whole lot of litigation about CC licensed works anyway. Most of the people who put their works under CC licenses intend for it to be shared, intend for it to be reused. And most of the time, like if you're doing something that kind of feels like it's fair, feels like it's in the spirit of how that work was distributed, like it'll be totally fine and the author will be okay with that. There's a very few cases where people are putting CC licenses on work that's like either intended to be commercialized and they're just like allowing some limited free use, or somebody has a business model where they like look for violations. That's pretty rare, but it does happen. Or somebody's just very particular about a particular kind of use that they don't like. Then you'll run into cases. Most cases where people have put a CC license on their work is just like, I made this thing, I want people to share it, I want people to do it in a way that feels fair to me, and anything that's basically that is okay. But maybe you should also consider the source of the material you're working with also. Like, was this produced by a commercial institution that has a business model where they allow some limited exceptions for free? Was this produced by an individual who was just like, yeah, I make things and like, I hope people reuse them, you know, give me credit. Was it produced, you know, like, yeah, so think about the source of the material and like how you think the author might feel about it. This is a very unsatisfactory answer to give to somebody if you're trying to give guidance to others, but that's more frequently than not how it works.
And then I think I have one more question I can ask, or if you want to, you know, cover like the favorite question you've ever been asked and you want to answer that, that's cool too.
Oh man, you know, my favorite one, I think, is maybe not the most like legally satisfying. It's just the one that delighted me the most. Is like somebody was like, oh, can CC licenses be applied to sculptures because our, you know, our library has a special collection of these works that were made out of like carved out of cheese, you know, and like, and yes, you can put a CC license on them. I don't know how you mark them. I guess like with a little placard to the side or something, but like, yeah, you can apply a CC license to any artistic work that can be copyrighted, like whether or not it is made out of cheese. And I just like, I never did see pictures of this this collection, but I just like, I wish I had seen it. Like I would love to go. It was somewhere too far for me to go see, or I would have gone to see it. Uh, uh, Another one, like somebody like, how do you acknowledge a CC license for a work if you would like to get it tattooed? You know, if you would like to have it like tattooed on you as art. And I did not have a definitive answer for this person. But we kind of brainstormed about some possible ways to do it. Like, so much like, how do you customarily acknowledge the like artist of a tattoo? And like, maybe when you're posting pictures of it, like on social media, you say like, by the way, like this is the art it came from, or like, you know, if people ask you, you acknowledge the source of the art, but do you have to have it tattooed on your body? Like, I don't think that you do. I think that there's probably a solution for that. But we did not have a prescriptive answer for, but like reasonable to the like the reasonable to the medium. And like, so whatever is customary for acknowledging the art for tattoos, and maybe especially if you're reproducing it in like a digital or print form, is like that you acknowledge the artist there.
Something about tattooing and attribution makes my heart happy though. That would be very cool. So
I've seen at least 3 people who also have like the CC a CC license symbol tattooed on them somewhere, like not as a license for art, but just like as a symbol tattoo. And I think that's delightful, but I don't know what that means for pictures of them, like that have the license on it. Is that marking confusing?
that we get CC by and see. And then maybe we can end with neighboring rights. So how does CC licenses interact with neighboring rights, and what about globally, across different countries?
So in the latest version of the licenses, neighboring rights are included, and those are rights that are not strictly copyright, but are usually rights that go alongside other contributors to a work. Like they may be broadcasting rights, they may be performers' rights, they may be things where people don't have a copyright in the right, but a copyright in the work, but in their jurisdiction they have some right to control the distribution of a work. And the CC licenses do in version 4.0 do license those rights to the extent necessary to like make use of the work, and you can see that that wording in the license. Previous versions of the license, which, you know, we don't recommend that people use anymore, but you may still see out in the wild. That does differ across versions. Like there are some national versions where those neighboring rights are more important, may have included it in jurisdiction ported versions, and other country ported licenses may not. That situation was very confusing, which is part of the reason we tried to harmonize it in 4.0 and make one version that applies internationally. In general, like especially with the latest version, if there are neighboring rights that apply to a work and a CC license has been applied by the rights holder, usually those rights are also licensed to the extent that you need to make use of the work under the license. So if there's neighboring rights that apply and the work is licensed CC BY or CC BY SA, you can use that under CC BY or CC BY SA and know that those neighboring rights have also been licensed to you. In previous versions, you may need to check, particularly if those rights are very important in your country. But they should be like, what we tried to do, especially with the latest version, was make it so that you are permitted to if a rights holder has applied that license, you are permitted to reuse the work under those CC terms and conditions. Even if they're regardless of what rights apply. For example, the database rights and neighboring rights shouldn't interfere with your ability to use the work as the license intends you to use it.
Thank you. And we're getting near to the top of the hour, so maybe we will end there unless folks have questions. But if there aren't questions, I just want to say thank you, Kat. These are always so informative and just fascinating. So I appreciate you being here.
Yeah. It's lovely to be here. I always enjoy these questions, even the ones that I can't really answer. And I'm sorry that I can't give you more clarity on non-commercial, which I know always comes up, and it's just one of those perpetual topics. Really enjoyed the cheese and tattoo examples. That one of the best things about working with CC is I enjoy getting to work with people. Like everybody who applies a CC license, basically their issue is I have something really cool and I want to share it. Like, how do I do that? So you get to hear about a lot of people's very cool projects.
Okay, so is it all right if I close out the room, folks? Any last questions? All right, so we'll let everyone get back to their day. All right. Thank you.
Thank you all. Take care.